everyone. I don't know how Reno High School rates, but you have a big room this morning. Nice big crowd to welcome everyone to We the People competition. This is Unit 5. I'm Michael Montero. I'm a district court judge in the 6th Judicial District of the state of Nevada, which is Humboldt, Pershing, and Lander counties. It's nice to be back here in Reno to help judge this competition. Good luck to our competitors this morning.
Good morning, my name is Damian Sennett. I work for the Lyon County District Attorney's Office. I'm a prosecutor in Fernley, and I'm looking forward to hearing his testimony this morning.
My name is Lucas Imbolstad. I work for the Senate Majority Leader, Harry Reid. This is my first year as a judge. Thank you for having me, and welcome and good luck.
Good morning, my name is Kevin Higgins. I'm a Justice of the Peace in Sparks. Good luck to you.
Thank you. You may be seated. Before we begin with our congressional hearing here this morning, our timekeeper's right in the front, correct? Timekeeper prepared. Make sure your cell phones are turned off today. And for Unit 5, we have selected question number 3, which is what fundamental American values are embodied in the 4th Amendment? You may proceed.
Regarding the case of Marcus v. Illinois, Judge Potter Stewart said, "The Fourth Amendment and the personal rights it secures have a long history. At the very core stands the right of a man to retreat into his own home and there be free from unreasonable governmental intrusion. The Fourth Amendment raises a fundamental question. At what point does the government give up its jurisdiction over the people?"
In his dissent of Olmstead v. U.S., Justice Louis Brandeis stated that the Fourth Amendment secures the right to be left alone, the most comprehensive of rights and the right most valued by civilized men. The Fourth Amendment contains values that can be traced back to England. In Section 3 of the 1628 British Petition of Rights, it states that no free man may be taken or imprisoned or be disseized of his freehold or liberties.
Another fundamental value embedded in the Fourth Amendment is the castle doctrine, summarized in the words of James Otis that a man's house is his castle, and whilst he is quiet, he is as well guarded as a prince in his castle. This concept holds the idea that a person's abode is a place in which the person has certain protections and immunities and may in certain situations use force to defend it.
In colonial times, a common English practice was the use of general warrants, which allowed the king's agents to search anywhere and seize anything they pleased. This concern led colonists to use their experiences with British rule to establish the Fourth Amendment. They expressed the need to specify the places to be searched and the things or persons to be seized when obtaining a warrant.
During the 1800s, the Fourth Amendment rights of free African Americans were often violated, as they could be seized without a warrant under the Fugitive Slave Act. An issue that took precedence in the 1900s was how best to enforce the Fourth Amendment. In Weeks v. West, the exclusionary rule was established, but it did not become controversial until the 1961 case of Mapp v. Ohio, which applied the exclusionary rule to state courts.
The 2001 Patriot Act greatly increased the ability of federal and state law enforcement agencies to search telephone calls, emails, health, and financial records of citizens with the intent to reduce terrorist activities. In the following months of panic after the terrorist attacks, this seemed like the best course of action to take. However, this act is too thorough in its sweep for terrorists, allowing for the violation of Fourth Amendment rights of individuals.
The Fourth Amendment has always been a persistent concern over the years because it is challenging to find the perfect balance between protecting the safety of free society and protecting the rights of an individual. In the Supreme Court case of Kylo v. U.S., federal agents used a thermal imaging device to detect whether the heat output pattern from Kylo's home was consistent with the high-intensity lights needed for growing marijuana in order to obtain the search warrant.
The Supreme Court held that the use of the device was a search, and that the government may not use technology to circumvent constitutional protections of privacy in the home. Furthermore, in the recent case of U.S. v. Jones, the government installed a GPS device on Jones's car, but continued to monitor it beyond the warrant's expiration date and jurisdiction.
The court ruled that this installation constituted a search and was a violation of the Fourth Amendment. These cases demonstrate the complexity of defining boundaries of technology. The framers could not foresee modern technological innovations like thermal imaging and GPS devices. Therefore, the Fourth Amendment raises the constant question of whether it should evolve along with these changes.
As James Madison wrote in Federalist 51, If men were angels, no government would be necessary. But because men are not angels, rules are put in place to protect others from danger. It may be hard to balance government power and individual privacy, but the Fourth Amendment has helped Americans keep their values and ensured citizens their rights. Thank you.
Thank you. This time, the judges will ask questions of the panel. And I'll begin with the question to the panel. Under what circumstances, if any, should law enforcement be able to arrest someone without a warrant?
An example of this would be a Terry search, which was established in the case of Terry v. Ohio. A police officer can come up to a person and search their outer clothing for weapons.
Another example is exigent circumstance, which has been defined in the case of Kentucky v. King. And this is when that if there is imminent circumstances such as imminent destruction of property or imminent danger, then they're allowed to enter a home or even make arrests without a warrant.
A recent example of this was actually at the Sparks Marina a couple weeks ago. A police officer was walking with his family, and he heard screams from the properties near the marina, and he approached the scene and realized that there was actually a rape going on in one of the buildings, and he could use the evidence that he'd seen to barge in and do his duty.
Overall, the circumstances to arrest somebody without a warrant is a lot less stringent than to search something without a warrant. This is because arresting someone simply means that you're holding them, but it does not necessarily prove their guilt, while searching their things is a way to prove guilt.
The next question, it was briefly touched on in the opening, but can you give examples of what colonial experiences made the Fourth Amendment important to Americans?
The Constitution, we were founded by mostly Englishmen, and so our Constitution has a lot of references to the English Petition of Rights, which is one of the first documents to mention habeas corpus, which is the right to be told what you're being detained for.
Colonial writs of assistance gave officials the right to basically barge in on a colonists and search anything they wanted. And they weren't specific as to what was to be searched and where they could find what was to be searched. And so that played a large role in the Fourth Amendment, because that's the reason that warrants nowadays have to specifically state what needs to be searched.
A specific example of colonial experience would be with the merchants, because we were big smugglers, and the British issued general warrants that are specifically prohibited in the Fourth Amendment now, that allowed them to search all merchants' ships for smuggled items.
Why has it proven so difficult to define what constitutes an unreasonable search and seizure?
On the other side of an unreasonable search and seizure, this is defined when it violates a person's reasonable expectation of privacy. And the issue with this is there's usually a two-pronged test, you could say, and this is whether there's a subjective or objective reasoning behind this.
The objective and subjective reasonable suspicion is objective is what society thinks of your personal privacy, and subjective is how you feel what your personal privacy is. An example of subjective is in the case of Katz v. United States, where a man was in a telephone booth and his conversation was recorded, which was unconstitutional.
In the case of California v. Greenwood, it was established that it is okay to search garbage that is left out in the front, because homeowners do not have a reasonable expectation of privacy, and therefore that is not an unreasonable search and seizure.
How do you define probable cause and when is it required?
Probable cause is the facts that officers need in order to say that an act has happened.
Reasonable suspicion is the step below this, and this is, they just have suspicion, but in order for someone to get a warrant, it's usually probable cause, and this is the step above, because they need more evidence or more reasoning behind that an act of crime is going to be committed or has been committed.
because they have to investigate whether this tip is reliable and research like the background of it.
However, in schools, a school official would just need reasonable suspicion, whereas if the school police officer wanted to do a search, they would need probable cause.
Why is there that distinction?
The case of TLO v. New Jersey established something called en loco parentis, which allows for the school to essentially step in the role of the parent when a child is at the school. And so that's what makes it okay for a school administrator to be able to search a locker with only reasonable suspicion.
And also the school administrator is working, well, the school policeman has to follow Fourth Amendment procedures, whereas the school administrator under local parentis doesn't necessarily need to do that in order to protect the rest of the students.
What values are served by requiring law enforcement officials to get permission from a judge to arrest someone or search his property? You know, I think I asked that question at just the really worst opportunity. The timer has indicated that we're out of time. So how about a round of applause for Richard Clark? Yes. Richard's over at the end. Nice job. Nice job, Richard. You know, I've noticed here this morning, this is the first panel where we've had 5 students. You have another kind of unique hurdle to overcome there, giving everyone appropriate amount of time and staying within these time limits. And boy, that's why you never see 5 judge panels. Because these judges can talk way too long. You don't know whatever you say. You guys did a really nice job today. You know, as a judge who has to deal with these Fourth Amendment issues pretty regularly in the courtroom, it's nice when you've studied the subject matter and you have the ability to articulate it. So much of what we deal with in the court systems is kind of a foreign language to lay people. And when I hear you using these terms, the proper terms, even some Latin terms today, to help explain this very complicated area of the law, that is really refreshing. I heard reference to a Terry search using exigent circumstances. We had a little discussion there about the difference between reasonable suspicion and probable cause, and when you have it perfected, please let me know. You did a very nice job. I also liked, I heard some new examples of some cases that I haven't heard yet today. The search of the garbage cans, that was a new one, and that is an issue that I've had to deal with as a judge. So it's nice to see how you incorporated all of these examples, and there's so much case law out there in this area. So I know there's so much that you could bring, and you're trying to bring as much of it as you can to this discussion. A nice job with that. I'm going to sit here and think for a minute about some negatives, and in the meantime, I'm going to give my colleagues an opportunity to comment.
Overall, you guys did a great job. You had a good knowledge of the material. It was well presented. There were a couple of times in your prepared introductory statements, maybe try to just memorize a little bit more and get a little more eye contact. And if you are going to read it, just kind of make the flow a little bit better. Benjamin, you had a really good recent example of problem cause and when police might be able to do something without a warrant. That was really good.
I was a little nervous about that one, though, because that may have to come before Judge Higgins down there at some point. We shouldn't be hearing about this yet.
Overall, you guys did a good job. You had a good knowledge of the material, the history of the Fourth Amendment, why it's necessary, and the limitations or the concerns that we have now.
Overall, good job, very good job. One thing specifically I really liked and haven't seen yet is what is arrest and arrest versus what is the search, and how that is applicable to the law. That it was, you guys brought it to my attention, and it was surprised no one else has brought it up. The other thing that was this is despite how many people are getting participants, very well dispersed. Very happy.
I think you're getting a taste of the struggle the court staff keeping up with electronic and technological issues. 5 years ago, we weren't issuing warrants based on people's Facebook accounts and GPS locators, and I issued those within the last few months. I've done warrants on both of those issues. So maybe nobody's told you this, but if you put it on Facebook, it's there forever. So the police get to look at it. There's no rule. So I thought you did a very nice team effort here. It was the presentation was well dispersed. I've got a copy of the Federalist Papers that I look at all the time, and I'm glad that Captain brought that up. It give us a little bit different perspective, and this is an evolving area of the law, and we touched on all those issues that judges need to be aware of all the time. So very nice presentation.